Over to you, Chaitanya.
Yes, thank you so much, ma'am. Uh, Good evening, everyone. I, on behalf of Legal Expatriate, would like to welcome you all to the second session of Practice and Procedure of Trial Courts in India. For today's session, we have with us Advocate Abhishek Avasti. Advocate Abhishek Avasti, a distinguished legal professional with over 2 decades of experience representing clients across various fora of pan India level, renowned for assiduous attention to detail and strategic approach to litigation. Sir has successfully handled complex legal matters with precision and dedication. Sir has primary practice before the Delhi High Court, district courts, and tribunal in Delhi and the Supreme Court of India, covering a diverse range of legal areas, including civil disputes, consumer protection, real estate, electricity laws, and cooperative societies regulation. With a deep commitment to justice and client advocacy, Sir continues to set a high standards in the legal profession. We are really honored to have you with us today, sir. Before I request Sir to take the charge of session, there are a few instructions for the participants. Participants are requested to not to switch on the video cameras and microphone while the session is going on in order to avoid any disturbance. And also, participants are requested to raise their hands in order to ask a question. Now, without further ado, over to you, sir.
Can you hear me?
Yes, sir, you're audible and the
Please,
screen is visible as well.
please. Okay, thank you. So, good evening, everybody. This is this short session of 1 hour. I have been given certain topics, basically on Civil Procedure Code (CPC), which generally guides the civil civil proceedings, or proceedings of like nature. Like nature means the proceedings of tribunals. They are also covered by CPC. So, for the first topic, which I'd like to start, is first I would like to give you a summary of how the suit proceeds. So you file a plaint. Thereafter comes the written statement, if necessary, a rejoinder. Then follows the admission and denial of documents. Then comes the stage of framing of issues. Now, from framing of issues, the trial starts. After the trial starts, then comes the plaintiff evidence. The plaintiff is asked to lead his evidences. Thereafter comes the defendant evidence. After the conclusion of these evidences, starts the final arguments. And the trial ends with the final arguments. So this is the brief, you can say, the breakup of the civil proceedings. This is how they start and how they end. Now, to the first topic, I think the best will be to start with filing. You file the plaint, and then, okay, we'll start with the parties then. Two things. There are two parties, as you know. There's adversarial litigation we follow in India, Commonwealth countries. So we have two plaintiff and a defendant. There may be more than one plaintiff, there may be more than one defendant. It depends on the nature of the case. Who can be joined as plaintiff? The person who has a cause of action, and who has a cause of action, and who has a to uh, claim to seek from the court against the other party. Defendant is the person from whom the plaintiff has to seek the claim. Defendant, they are also of two types. One is a necessary party. That is a very important aspect which you should know. Necessary party and proper party. Who is a necessary party? Suppose I file a suit for recovery. I become the plaintiff. Then I have to, who will become the defendant, from whom I have to get the money. That is the relief. The person against whom I am seeking the relief is the necessary party, without which no
Sorry
decree
to
can be
disturb you,
passed.
sir. But just to make sure, are you sharing something on the screen because it is not visible?
Because I want to share, I have brought some application to show you that will be easy for the students to understand. I am clicking on share, but it is not coming. I don't know what's the problem.
Okay, sir, let me just check if it is.
1 minute, please wait.
Yeah, sure, sir.
Or I can do one thing. Can I send it to you? You can share it with the screen.
Yeah, sure, sir. No problem.
Please hold on. Then. Please hold on. Please hold on, everybody. Here, just. Can I have your email?
Sir, I called you a few minutes back. Is it your WhatsApp number? So I'll just, if it is possible, I text you over there. It will be easy for
Yes,
me
yes.
to
Why
share
not?
it
Why not?
from there.
Please, please,
Yeah,
please.
yes, sure.
There's some. Wait. There's some synchronization problem which is coming here. Wait. I think this Zoom is going on. No problem. Okay, let me proceed. Let me proceed. Waste time. Otherwise, no problem. Can you hear me?
Yes, sir,
Hello.
perfectly fine.
Please. I'll just try to share it when I about to end my this lecture. That will make things clear. We have just 3 documents, 3 applications I have. I'll just share it. Let me finish with my lecture first. Now, thing is that I was talking about necessary party and proper party. Necessary party, again, I'll come to that point, is the party against whom you want to claim the relief, the final relief, against whom you want to get the decree passed, without which no decree can be passed. If I want to file a civil suit, naturally I have to implead the my debtor from whom I want to recover the money. I am the creditor. So I want to recover the money. So the debtor has to be the party. He is the necessary party. Proper party, again, is a person against whom I am not claiming any relief, but against without presence of which the court cannot pass the settle all the issues effectively, cannot pass the decree effectively. Suppose in the same suit, food for recovery, there is a party which is which suppose my debtor says that I have paid that money to suppose Mr. B, and it is on your request I paid it. So I said, no, I didn't request you to pay to, I know never directed you to pay to B and absolve yourself. So I'll make that B a party, that he will become a proper party and A will become the necessary party. I think it is clear to you now. These are the 2 types of parties. Now, this becomes necessary when you add parties, add defendants or plaintiff under Order 1, Rule 10, Sub-Rule 2. So I'll start with this only. I'll start with the Order 1, Rule 10(2) of CPC, which gives the power to a party, to a litigant, to add either defendant or plaintiff. So what is that Order 1, Rule 10, Sub-Rule 2, which is very important, which says is that at any stage of the proceeding, now at any stage means before the passing of any final decree, the court can entertain such application, and the court suo motu also, without the application from either of the party, the court can add any party or strike out any party. So at any stage means before the passing of decree, at any stage. So what the court can do when one of the applicants, one of the parties, they file an application, the court will simply the court will issue notice to the other party. Then the court will hear both the parties, and after hearing the parties, the court will decide whether to strike that person as plaintiff, to add somebody as plaintiff, or to add as a defendant somebody, to add a plaintiff or a defendant, or to strike out the plaintiff or the defendant. Now, in case of deciding whether this the person has to be added as defendant or not, the court will certainly try to find out whether this defendant is a necessary party or not. Who is a necessary party? Whether this one is a necessary party or the proper party. And in case of neither of them, if it is neither a necessary party nor a proper party, the court won't allow this application, because then it becomes an totally irrelevant party. Because it means in the absence of such a party, the court can effectively draw a decree or pass an order. So there is no need to add such a person as defendant. Now, the moment this a person is added as a defendant, one thing which has to be seen is the limitation. If he is added as a proper party, then the limitation doesn't apply. The limitation applies when you are adding somebody as a necessary party. Why? What is the reason? The reason is very simple. As I told you, necessary party is the person against whom you are claiming the relief, against whom the decree will be drawn. Suppose only one party was there, Mr. A. Now you want to join Mr. B as necessary party. It means you want to claim a relief against B also. A and B jointly or severally, whatever it may be. In that case, it means the suit against B will commence only when the summons are served upon Mr. B. And why I'm saying so, it is order, it's given in order rule, order 10 itself, it has been given. It says that limited that subject to the section 21 of the Limitation Act, the suit will commence against a new party when the summons have been served upon it. So it means for Mr. B, the suit will commence only when the summons have been served upon. And if suppose that suit for against A is maintainable as per the limitation, but for B, the limitation has passed, had withered away. In that case, you have to be very careful. Then in that case, B cannot be added a party. Even if it is added, the suit is barred by limitation against B. So in case of necessary, when you are adding a necessary party, it becomes it becomes important to keep in view the limitation period. And then comes the consent also. The consent of when you add a party, court adds a party as a plaintiff, the consent also becomes necessary. Consent of the person who is being added as a plaintiff is necessary. Also, the plaint has to be amended. Whenever these parties are added, plaint needs to be amended, particularly where defendant, because this provision talks about defendant. When defendants are added, the amendment of plaint is must, compulsory. Now, after you have known something about this addition of parties and and deletion of parties, then comes an important, again, another aspect is amendment of plaint. Moment you file a plaint, and if you find something is missing in the plaint, and it is a material fact, I'll just tell you under what circumstances this first amendment of plaint becomes necessary. For a genuine party and who is fighting bona fide. I'm not talking about malicious litigants or malafide litigants. There may be many reasons for that. But for a bona fide person, bona fide litigant, why it becomes necessary? It happens many times. In my experience, my practice also, it has happened. Sometimes you miss out material facts which are necessary, which should have been mentioned. And at filing, after filing, or maybe after getting the WS, you come to know, no, this should have been filed. Then what you have to do, you have to move in application, the order 6 rule 17. 617. 617 बोला जाता है इसको. बड़ा common है. This is a very commonly invoked provision of CPC. 617. 110 also very important. 110(2). Sub-rule 2, and this 617 is also very important, commonly invoked. And then when can you amend the plaint? You can move freely and you can expect this will be amended before the settlement of issues. Settlement of issues, becomes very easy for you to move a bona fide application. Generally, the court allows. But the moment it is said the issues are settled, it means the trial has begun. And then if you move this application, you have to show some very good case. Good case means that even you were diligent, you could not uh, bring those facts to the record. You were diligent. The litigant was diligent, but in spite of being diligent, he could not bring all those facts to record. You have to show this. This thing becomes necessary after settlement of issues. Means a special case has to be made out. Now, what can you amend in a plaint? You can amend the cause of action, all the facts, factual paragraphs you can amend. Amend in the sense you can add certain facts, important facts, or you can also uh, change, you can add some relief. But here again, you cannot alter the nature of the suit. You can add one relief. Suppose you have asked for declaration or you have asked for possession, but you have to be declared as an owner. The court says no, first you amend it. You have to amend, you can add possession. But you want to make it a recovery suit that will alter the whole plaint. You cannot do it. You cannot alter the nature of the suit, the nature of the plaint in the garb of amendment. Amendment is only meant for bona fide litigants for some bona fide mistakes. You cannot change the cause of action completely so as to change the nature of the suit. You cannot change the relief also. You cannot add so much of relief, new reliefs, so that it alters the nature of the suit. Now, generally the court allows such kind of amendments if the court thinks that such material facts are necessary to effectively adjudicate upon all the issues. In those cases, the court will generally try to allow the application. Now, relief, one thing which has to be seen here is, again, which the problem which we faced in 110.2. Suppose you want to add a relief, and the relief is again it's a new relief totally, then will come the point of limitation. Who are this relief? Suppose you are adding declaration was there or possession was there, you are adding declaration. Then again it has to be seen as far as declaration is relief is concerned, your suit is within limitation or not. If it is not in limitation, then certainly you cannot amend the plaint. So again, this limitation, point of limitation is very important when you are adding any new relief to the existing ones. So this limitation point has to be seen. Order 1 Rule 10.2 in case of necessary party, and then 617 when you are amending the plaint and you are adding a new relief or a new claim, then this limitation has to be checked always. Now these two things, now comes the limitation. Suppose Order 6 Rule 18 says the court has accepted your application, court has allowed the amendment. The court will generally give 14 days time, or some other time has been given, the things has to be complied with within that. Now, once you have added the parties, you have amended the plaint, now starts the hearings, day-to-day hearings. Hearings comes very important aspect, adjournments. Again, this is one of the topics which I have to cover today. Adjournments. Adjournments, which is Order 17, deals with adjournment, CPC. CPC Order 17, Rule 1, what does it say? At any stage, party can move an application, either party, that and pray to the court that today it should be adjourned. It should be adjourned to some other date. And today we have some problems, and problems which are outside the scope, which are outside the control of the party, and which is you can say the party um, is in some difficult situation. So an adjournment can be prayed under Order 17, Rule 1. Now, one thing which this Order 17, Rule 1 says, that a cost may also be imposed. The court may grant this application subject to cost imposed on the other party. And generally CPC puts a restriction, a capping on the number of adjournments a party can take during hearing. It is 3. Party cannot take more than 3 hearings on a hearing, 3 adjournments during hearing process. But it is rarely, I have not seen any such case where it has been strictly followed. Generally, court has to grant adjournments because adjournments, one thing we forget, that it is not because of only 2 parties or 2 pleaders adjournments happen. Adjournments happen for many other reasons also. Maybe the presiding officer is not well, is not holding the court, could not hold the court, cannot call the matter for something. And again, there will be an adjournment. Though those situations are not covered under Order 17, Rule 1. But adjournment takes place, what I'm trying to say out, adjournment takes place because of other factors also, and not depends only on the will of the pleaders or the parties. So, but for the theoretical purpose, it is important for you to know that 3 cappings have been put, 3 adjournments per party during the hearings. Means both the parties can take only 6 adjournments in total. Now, there are many under rule, if you see Rule 2, there are many other conditions which have been put. And these conditions are rarely followed because one condition is that says that pleader is engaged in some other court, you cannot seek adjournment on this ground. Your counsel is busy in on the legs before some other bench, you cannot seek. And then when you can seek only when you have some exceptional circumstances beyond your control. Then only you can seek adjournment. Also, when you are seeking adjournment on pleaders not available or not well, then court can give you adjournment only when it is satisfied that you have tried to engage some new counsel and you could not engage for that date, and that is why. So practically, if you ask me, it is very difficult. You have paid amount of fees to the advocate. If advocate is not well, so and then you expect the litigant to engage some other for that particular date. It is an impractical thing. It's not practical. The impractical thing which is expected from a litigant, and that is why this 10 rule, this Rule 2 provisions, they have become, you can say, almost redundant. They don't have any value, practical value. Theoretical it has, practical it doesn't. So, and my suggestion is to all those advocates, lawyers who are into practice or who will be going into practice, law students, that adjournment should be sought bona fidely. If you are seeking bona fide adjournment, court will grant it. No doubt about it. But mala should be, you should refrain from asking mala adjournments because it somehow it will bring down your reputation in the eyes of the court, the eyes of the other party also. So better to go for a bona fide adjournments. Now, after adjournment comes another important topic, which is transfer of matters. This is very important. Transfer of matters from one court to the other court. Transfer may be from one district court to the other district court. transfer may be from one high court to the other high. Section 22 of Civil Procedure Code, it talks about the general powers to transfer. 22 and 23, they are to be read together. Section 22 and 23 of the Civil Procedure Code, they are to be read together. What does the 22 say? That an application of either of the parties, the court will transfer the matter, the suit or pending before it, or other proceeding pending before it, to the other court. After which the court thinks is the competent court to decide to try the matter, dispose of the matter. Now the thing is, where is this application to be moved? Suppose a suit can be filed in several courts, or two courts, or more courts, and it has been filed in one court. Suppose it has been filed A, B, C, it can be filed in A, B, C courts. And it has been filed initially at A. A defendant is served with this notice. Defendant comes to the court and moves an application. Now, where this application the defendant has to move? A, B, C, three courts. Now, if A, B, C, the three courts, they are subordinate to one appellate court. The appellate court is common to all these three courts. It can be moved in that appellate court. Where the appellate courts are different, but these three A, B, C courts, they are common to one high court. They're subordinate to one common high court, then before this high court, the application for transfer can be made. Now, suppose it is A, B, C court, they lie under different high courts. Then which high court? Then the high court in which, in whose jurisdiction the court in which the suit has been instituted, has been brought, there you have to move an application. So these things where this is about general powers, the court to transfer. Then comes section 24. Again, 24 talks about this, that where general powers of the district court and the high court to transfer. So what it says, the high court or the district court may transfer any matter, any suit or appeal or proceeding pending before any court subordinate to it, to any other court subordinate to it, which is competent to try or dispose of this suit or appeal or proceedings. So what I'm saying is, High Court or the district court can transfer any matter, any suit, any proceeding pending before any court subordinate to such High Court or district court, to any other court subordinate to such district court or high court, which is competent to try and dispose of this matter. Then other things what the high court also, the district court can do. The high court, district court can withdraw any matter, any suit, any appeal or proceeding pending before any court subordinate to it, and try and dispose it of itself. Or may first transfer it and thereafter retransfer it to the court from where it was earlier transferred. So this was the general power regarding transfer given to High Court and Division Court, Section 22, 23, and 24. Then comes the power of Supreme Court under Section 25 to transfer the matters. What does it say? The Supreme Court, on application which is to be made before Supreme Court by either of the parties. And the Supreme Court, after issuing notice and after hearing both the parties, may transfer any suit, appeal, or proceeding from one high court to any other high court, or from one civil court in one state to any other civil court in another state. So in such cases, the question arises, the point which arises for consideration is the moment you transfer it to some other state, what will be the law applicable? The law applicable now in all such cases, wherever it is transferred intrastate or interstate, the court to which it has been transferred may rehear it, may hear it afresh, or may start from the stage where it was left by the other court, preceding court. Now, in case of interstate transfer, which talks about Section 25, the law which would have been applicable in the court where it was originally instituted will apply to the case which had been transferred to the other state. This is what Section 25 says. And it is logical also, because from some reason it has been transferred, but now it is to be tried, disposed of by some civil court of another state or high court of another state. So logically speaking, the law which was applicable earlier has to be applied now in the present proceedings. So this was all about transfer the general power which the High Court have, the district courts have, and the Supreme Court have. They have under CPC to transfer the suits, appeal, or any other proceedings. Then we have finished addition of parties, procedure of a partner, adjournments. Then I'll just see what's left. Yes, we have procedure of filing evidence. What happens if the opposite party does not appear after getting summons? Two topics we have left. Yes, evidence is also important. Two types of evidence we can tender before the court. One is documentary, one is oral evidence. In civil matters, which are guided by CPC, witnesses, they are supposed to tender their chief in form of an affidavit. Now, what is this affidavit all about? Affidavit is something which is given on oath, and it contains the documents in form of exhibits. Now, what are those exhibits? Exhibits are only original documents, the documents which can be tendered, the original documents which are tendered before the court, they are exhibits, and documents can be tendered only in original. It means only original documents can be tendered as evidence before the courts. If you are tendering a copy, not the original document, then it cannot be exhibited. The word exhibit cannot be written on that document. So what has to be written? It is marked simply. But is it admissible? Yes, it is admissible. Till the other party is not disputing that copy also, if they are admitting their signatures, they are admitting the execution of the document, these copies are admissible piece of evidences. The contents can be read into in support of the pleadings. So Now, what I'm saying is CPC, whenever witnesses are to tender their testimony, it has to be tendered first on an affidavit. Then comes the cross-examination. Cross-examination is done by the other party. What is the object of cross-examination? First object is to falsify the witness. Whatever witness is saying is wrong, is incorrect. To challenge the trustworthiness of the witness. And second, which is most important, is to extract, to elicit facts which go against them, against the witness, against the party for whom the witness is appearing, and which supports you. These two things are very important for cross-examination. And so therefore, cross-examination and chief. In fact, chief is not so, it doesn't demand much skill, but I'll tell you what is the skill. But that cross-examination is a very, you can say, skillful art. It needs a good skill. That advocate who is counsel who is cross-examination examining, he should have a good skill in that, good knack in that. Then only he will be able to cross-examine. And what questions are to be given in cross-examination? It is the not open, closed question, leading questions. Leading question means the questions which lead you to particular answers. It means you know the answer, but you want to take it, you want that answer to come out from the mouth of the witness. And therefore, you will put such a question that he will be forced to give that answer in one word or two words. That is the leading question. Opposite to this, contrary to this, comes the chief. That is, I told you in affidavit. The chief says that suppose you are not, it is not being conducted by an affidavit, then it has to be conducted in open court. In that case, the counsel will be putting all open questions. What are open questions? Why did you go there? When did it happen? Because it has to be conducted by the counsel of the litigant for whom the witness is appearing. Then he will put all sorts of open questions. The witness is free to move here and there. So witness is in chief free to move here and there because he is telling you something in support of his case. But here also the trick is that the affidavit should be that the chief should be short, crisp, and material to the point. There should not be repetition. There should not be unnecessary exaggerations, additions, because the duration of cross-examination depends on the length of the chief. The more you go into chief, the more he will be subjected to the cross-examination. So the cross should be short, material, to the point. If it's not being done, it's done in open court without affidavit, then leading question, this open questions have to be called non-leading questions, where the witness is free to go here and there. But contrary to this comes the cross-examination. Cross-examination, you cannot allow the witness to go here and there. So what questions you have to put? You have to put questions, the answer you know. You cannot put questions which the answer you don't know. Means the answers you know will not be favorable to you. Better not to put those questions. And the answer will come in yes, no, or you want to extract some words from it, then you can put that question. But should be leading. It should lead you to some point. Lead you to your answer. You cannot leave your witness free to go here and there. You cannot know. That will destroy your cross. Will go against you. You have to take control of the witness. So leading questions have to be put to the Non-leading you cannot put in cross-examinations. This was about the evidence portion. I'll just affidavit. I'll show the affidavit also. Now, the sixth point was what happens if opposite party does not appear after getting summons. If after getting summons, the opposite party is not either first he appears or he doesn't appear from the first date, then naturally the court will proceed ex parte against that party, against that litigant. If the court moves ex parte, it becomes one-sided without any opposition. In that case, the suit becomes very easy. It becomes easy for the plaintiff to get the decree passed the moment other party is not appearing. Maybe after the, as I told you, maybe initially, or after appearing for certain time, may fail to appear. In both the cases, they will be proceeded ex parte. Now, I think we have covered all the topics for today. If you can, if somebody has any questions, you can put any. Does somebody have any question?
Hello.
Does
Hello.
somebody have any question? Yes.
Sir, this is Advocate Abhishek also from Kanpur, UP.
Okay, please.
Sir, my first question is, what is, sir, admission and denial?
Yes. Good question. Good question. See, plaintiff in support of the plaint files certain documents. The defendant also files documents in support of the written statement. What happens is the court, for the convenience of the trial and to reduce the to make it more clear, what it asks is to put the plaintiff also, defendant also, to put their admission denial in form of an affidavit. What the plaintiff has to do, he has to make a list of all the documents filed by the defendant in form of an affidavit. Then what he has to say, whether is he denying the contents. Denying here means he is not in consonance or he doesn't agree with the content. Simply. So if he doesn't contain, he's not can say normal, or he's opposing those contents, he has to deny it simply. Sometimes it happens that suppose you have received an email or received a legal notice. In such cases, you cannot deny the receipt. So you say receipt admitted, but contents denied. Content denied means here you don't agree with the contents, simply. Again, the defendant also is supposed to do the same with the plaintiff. He has to make a list of all the documents which have been filed by the plaintiff, and then he has to deny it individually. Deny or admit it individually.
तो सर ये कब होता है, मतलब डिफेंडेंट अपने डब्ल्यूएस में इसको डिनाई करेगा तो प्लेंटिफ ने लगाया हुआ है,
वो सेपरेट
अलग से डिनाई करेगा?
वो सेपरेट एक ऑर्डर होता है बिफोर इशुएंस ऑफ दिस सेटलमेंट ऑफ इश्यूज. एक ऑर्डर पास करते हैं. दिल्ली में तो ऐसा करते हैं. आई डोंट नो व्हाट इज हैपनिंग अदर प्लेसेस, बट दिल्ली में बिफोर सेटलमेंट ऑफ इश्यूज दे आर डायरेक्टेड बोथ द पार्टीज कि वो फाइल करेंगे अपने एडमिशन डिनायल फॉर्म ऑफ एफिडेविट. It is always given in form of affidavit.
Okay, in the form of affidavit.
Affidavit में देते हैं, ओथ पे. हाँ, बिल्कुल.
Okay.
परजरी हो सकती है. अगर आपने झूठ बोला तो परजरी हो सकती है. जी.
मतलब हमें क्या, अगर हम एज ए डिफेंडेंट हम कर रहे हैं तो हमें अपना अगर डिनायल एडमिशन करना है तो हम एफिडेविट पे देंगे, प्लेंटिफ के रिकॉर्ड्स को देकर, डॉक्यूमेंट्स को.
You have to say beforehand. वो actually आपसे they want an assurance. The court wants an assurance that if suppose it will shorten the trial process. Suppose you are admitting a document. Suppose out of 5 you have admitted 2 documents. तो controversy dies down as far as who are these two documents. जहां तक ये दो डॉक्यूमेंट का सवाल है, तो controversy dies down. The controversy
Right,
is
sir.
now about the three documents which you are denying. Again, this same will happen, vice versa will happen with the opposite party. उसके साथ भी यही होगा. मान लो 4, 5, 6 डॉक्यूमेंट्स, उसमें से एक को एडमिट कर लेता है. तो जहां तक वो एडमिटेड डॉक्यूमेंट का सवाल है, वो उसमें वो कंट्रोवर्सी खत्म हो जाती है, डिस्प्यूट खत्म हो जाता
Fine, fine. मेरा नेक्स्ट क्वेश्चन सर ये है कि ऐसे इन माय केस आई एम अ डिफेंडेंट ऑफ अ जजमेंट डेटर. तो जो बैंक है उसने हमारे जो मेन पार्टी है, जो जजमेंट डेटर है, उसको मेन पार्टी
Sir,
बनाया हुआ है. और
sir,
जो second
sorry
है.
for the disturbance.
है.
Hello.
प्लीज
Sir, can you continue in English? We couldn't understand what you are trying to say.
Actually, I am comfortable in Hindi in language.
ओके.
Sir, other part is
No,
cannot.
Mr. Srivastava, you complete in Hindi, but I'll just translate in English. Whatever you are putting the
Yes,
question.
sir.
Thank you, sir.
सर मेरा क्वेश्चन ये है कि इससे मेरे पार्टी में मेरे जजमेंट डेटर मेन पार्टी है, और उसके बाद उसके फादर थे जिसको बैंक ने गारंटर बनाया था, गारंटर कम बोरोवर सेकंड पार्टी बनाया था, और
हाँ.
जो गारंटी जिसने लिया था उसको थर्ड पार्टी मतलब बनाया था. तो
Correct.
इसमें जजमेंट, तो इसमें नेसेसरी पार्टी कौन होगा और प्रॉपर पार्टी कौन होगा? इन माय केस जजमेंट डेटर एंड उसके फादर जो हैं वो क्या होंगे, और जो गारंटर है लोन का वो क्या होगा?
Okay. So what the question he has put is, let me translate. Question is putting is that the decree has been passed. Now execution proceedings are going on, and the proceedings are going on against the judgment debtor, his father, and the guarantor. तो लोन किसने लिया था? फादर सन ने, या दोनों ने एक ही ने लिया था?
नहीं, लोन जो पास हुआ वो सन के अगेंस्ट हुआ. सन ने लोन
फादर
लिया, लेकिन फादर को बोरोवर बनाया एंड गारंटर
को
सेकंड
borrower,
पार्टी.
ठीक है, तो वो बोरो हुआ ना. एंड
यस,
गारंटर कौन है? गारंटर थर्ड है कि फादर है?
गारंटर थर्ड पार्टी है.
Third party. So, ठीक है. So what he's saying is the decree has been passed against father, son, who are the co-borrowers, and of course the third party, the guarantor, has also been impleted in the execution proceeding. His question is, who is the necessary party, who is the proper party? So, chalo, let me test. Can you say something? Any participant can answer this question? Amongst the three, who is the necessary, who is the proper? Can anybody can answer this question?
Sir, guarantor can be prosecuted, sir.
Huh?
Guarantor will be like
He is
imposed.
asking who is the necessary or who is the proper party. Tell me.
Guarantor is the
Son and
necessary party.
son and father will be the necessary party, and the guarantor will be the proper party.
Okay.
Yeah.
Any other answer?
Sir, who has taken loan, he will be the necessary party. Guarantor will be the other party.
Guarantor will be
Other party, second party.
the
First
proper party.
Yeah, proper
The guarantor will also be a necessary party because the person has a right to sue any one of them.
Yes.
Yes.
This is more appropriate, and this looks to be an appropriate answer. See, as I told you, the necessary party, you can claim relief. Now here, you can claim relief. The creditor can do one thing. He can leave these two persons, father and son. He can go severally against this guarantor. He can choose. The creditor has the right to choose between this borrower or the guarantor. The guarantor also stands in the same footing. If the father and they say I cannot pay the loan, then he can go against the guarantor. So guarantor is also necessary party. All the three are necessary party.
Sir, if guarantor doesn't have anything to pay, what remedy he has, sir?
Then he will face jail. I think father son will also face jail.
He can
All
go.
the three will face jail.
Guarantor also can prosecute and he can go to jail, sir.
Yes. Why not?
But like guarantor,
And-
I don't have, sir. The thing is, like, if my brother has taken a loan, I don't have anything. I just guaranteed it. I mean, I just signed this document. That's
If
it.
you
I
are
don't have any.
guaranteed, then you have become a guarantor. Be careful
Oh.
whenever you sign as a guarantor, please.
Okay.
Guarantee means guarantee. It doesn't mean you are doing it for brother or you're doing it for friend.
Okay. So the thing is, the first party has been died, like mother has died, and son has a second applicant. So can the son be like prosecuted to that, or he got
Mother,
any?
sorry, can you repeat it once again?
Sir, mother has taken a car loan, sir, vehicle loan.
Mother has taken the vehicle loan.
Yeah,
Okay.
vehicle loan. Mother has died, sir.
Mother has died. Okay.
Died. And second party is the second son.
The second party is the second son. Okay.
Yeah. And a guarantor, I have no idea, sir. Maybe guarantor or second party, I know that. So can he prosecuted, sir, by the creditor?
Why has
Can
been become the second? Why is the second party? Can you elaborate on this?
he just sign applicant, co-applicant, sir, because mother.
Means he's the borrower.
Yes.
He's a co-borrower. He can be prosecuted. Why not?
Oh, even if the first applicant has died.
Yes, yes, yes. First applicant is dead, but he is the borrower. Everything falls upon him now.
Oh, so he can be
Because
fixed.
you cannot enforce liability against dead persons.
So I mean, we simply can't go to the court saying that the first applicant has died. This is a death certificate. Nah, we can't get rid of it.
But because it happens that, see, you can say that in one way the mother son both were having share in the vehicle. You know? But
Yes.
after the death of the mother, the son becomes a legal heir. Correct?
Yes, sir.
So he has also acquired interest, maybe a part of interest, but he has acquired the interest.
No, sir, they are the joint borrowers, I think now, no?
They are joint borrowers, they cannot escape.
Yeah, and the son is liable.
Yes, yes, he's liable.
Yes.
But sir, son has no idea about it. Like he just signed
Doesn't
it
matter,
because mother told.
sir, he has an idea or not.
Oh,
But he has signed it,
The
no?
idea
Yes,
means what? He is the co-borrower, he must have signed the application.
Must have signed the
Sir,
application, correct.
Sir, usually what practice they do that they just give you an application form, they just sign it, and that's it. I mean, then I asked the son. He said, "No, I have no idea. They just send me a form. I just signed it."
The
That you
fault,
can't say.
fault is ours, no? Fault is ours. We are not reading the document.
If you have not read the document, then he is in trouble. Proper there is a
Formal or informal signature, it is liable.
Correct.
Yes, yes.
All right.
If you have put a signature, then it is understood that you have gone through it and you have made a signature after understanding the content. That is the implied thing. It is implied.
Okay, it's not okay. Okay, sir.
It is that the law puts a presumption on you.
Okay.
Then you have to disprove it that I was an illiterate person, a blind person.
Yes, sir.
Sir, in this particular case, let's add one more condition. In her will, her mother has not add any of her name. Okay, so all the properties will went to first son and the daughter, and the second son, who is the borrower, and now he has uh, no no money left from her mother, or no property from her mother. So in that case,
Generally, what happens? Sons are liable only to the extent they inherit the properties. Sons are liable, but here you are talking as a co-borrower. So the loan.
No, sir. He's asking what means. After the demise, the loan has taken in her name and was a co-as applicant.
Okay, sole. She was the sole applicant.
After she gone out, she is also having an elder son and a daughter. But those elder son and daughter only get the shares, all the shares of the mother, not the second son. Then how is he liable to pay the loan amount?
correct.
If they are not co-borrowers, they are not liable.
Yes. Firstly, if he is not a co-borrower, he cannot be made liable.
No, sir. He is asking. He is a co-borrower, but his mother doesn't leave any of the property to his will.
It doesn't matter.
So what is the condition for this?
Means the mother has written a will again in favor of the elder brother and sister, and nothing given to this fellow who is a co-borrower.
Yeah, correct, sir. So now in this situation, what will be the scenario has changed, like whether he has to pay that money back or no.
Sir, I'll
These
share
two are
small thing.
independent, my
I'll
brother.
share
These
small
two.
thing.
Sir, if it is ancestor property, she is
I'll
having
nine,
that.
1 minute, please. I'll answer that question. See, first thing, the co-borrower is liable to pay for the loan taken. If the co-borrower is unable to pay, the bank can sue the property inherited. Then they will file a civil suit against the legal heirs to recover the balance amount from the property they inherited. So first will be co-borrower. If co-borrower is unable to pay, if he's not having any resources, he is bankrupt, then they cannot recover any money since they are the legal heirs, mother legal heirs. From the property extent, they can recover. This is the thing going. Okay.
Correct.
Sir, even a second
Abhishek
son is
Ravapur.
also the legal heir. We can't avoid that second son is a legal heir. And then
If the mother property self-acquired property, if the mother property self-acquired property will be, she is at liberty to write will according to her choice. If the property belongs to ancestral property, then he can challenge the will. The second son can challenge the will. But if it is mother's own property, she can write will to any one son, two sons, third party, fourth party. It is her choice. But if it is
Sir,
ancestral property, they cannot, second son can challenge the will. Okay.
okay, sir. If the ancestor property has been transferred to the title of her own, that person means how it can be claimed by the legal heir.
Challenge the will. Challenge the will.
No, sir, I'm
Challenge the will
asking.
in the court.
And the husband is transferring the ancestor property to his wife name. Okay. After that, she is liable for the title of deed. In that thing, how we can say this is ancestor property because the title has been transferred to the in the name of her. So now we can say that it is an ancestral property. He has to say that it is my it's in under my name. It comes under for my.
The documents will be there hierarchically, right? How she got the property, either gift deed or something like that, right? It
No,
has
sir.
a predecessor document will be there.
Share for two brothers, then that share property will given to her wife. What does that mean?
Even
Two
though
brothers having the property, sir. It comes from their father, and then second brother is transferring the property to his wife after he got demised. By using the will, something else. Once she got the rights, after that only the legal heirs should be there.
See, I'll tell you
If
one thing.
it comes,
If our sons are major, they can sue for the partition from that will. Okay, if they are minors, and if the wife sell the property before they become major, nobody can help it. She is the legal owner as of now due to will. Okay, because her husband has given a will, she is having the owner. If she is selling that property and taking that money, nobody can question her. But if she is not selling, and if she is giving only to one son, the other son can challenge that will. Okay, but if she is selling and taking that money, nobody can help it because already she got the property through her from her husband. She is selling now. She is having every right to sell. It is valid transaction. But
sir,
if she
I'm having.
सर मेरा क्वेश्चन लीगल हेल्थ पे है सर. इस सेम केस अगर प्रोसेस सर्वर जो है उसने अपनी रिपोर्ट में ही मेंशन किया है कि जो को बराबर है उसकी डेथ हो चुकी है बिफोर सबमिटिंग द फाइलिंग द सूट. ये उसने अगर प्रोसेस सर्वर ने अपने दो रिपोर्ट में मेंशन किया है और प्लेंटिफ बैंक को ये पता है क्योंकि संबंध तो प्लेंटिफ बैंक ही भेजेगा आफ्टर फाइलिंग द सूट. तो संबंध में अगर प्रोसेस सर्वर ने ये मेंशन किया है कह कि को बराबर की डेथ हो चुकी है. अब ये नॉलेज में भी है प्लेंटिव बैंक के मगर प्लेंटिव बैंक इस चीज को नेग्लिजिबल करता है मतलब अनदेखा करता है उस पर कोई ध्यान नहीं देता है. आफ्टर द पॉइंट रेजिंग बाय द डिफेंडेंट काउंसिल जब डिफेंडेंट के एडवोकेट उस चीज को रेज करते हैं कि इन्होंने ऐसा किया है और सूट आफ्टर द को बोरो की डेथ पहले ही हो चुकी थी उसको भी इन्होंने पार्टी बना करके उसके खिलाफ एक्स पार्टी जजमेंट ले ली डिग्री हासिल कर ली. तब जो प्लेंटिव बैंक है वो 6/17 का अमेंडमेंट लेके आता है ऑर्डर 22 रूल 4 में लीगल हायर्स को बराबर जो लीगल हायर्स है उनको ऑन द रिकॉर्ड लाने के लिए. तो क्या ये मेंटेनेबल होगा सर इस स्टेज पर? जैसे आपने बताया था कि 6-17 आप कभी भी ला सकते हैं, प्लेंट और डब्ल्यूएस में आप अमेंडमेंट किसी भी स्टेज पर कर सकते हैं, जो कि कहा जाता है, तो क्या ये मेंटेनेबल होगा?
हाँ, it is
क्योंकि
maintainable at
पहले
the appellate stage because appeal is considered to be extension of trial. ट्रायल कोर्ट के प्रोसीडिंग से उसका एक्सटेंशन माना जाता है अपील में, फर्स्ट अपील खासकर. So in appeal also the courts can add the parties because here what we are saying is the parties, the co-borrower died and the bank never knew it or treated it negligently. Then the court that they got a decree against the co-borrower. But एक बात बताओ आप, जब वो डेथ हो गई है तो how
Yes,
the
sir.
court will proceed and pass a decree against the co-borrower who has already died on the date of filing of suit. जब सूट फाइल हो रहा था,
बिकॉज प्लेंटिव बैंक के वकील ने उसको उसको हाइड किया, बताया नहीं कोर्ट
एक
को,
बात
ऐसा हो चुका है,
बताओ.
उन्होंने मेंशन नहीं किया. अभी मेरा नेक्स्ट क्वेश्चन सर ये भी है कि क्या ये जो प्रोसेस सर्वर की रिपोर्ट है, जैसे कि अभी इलाहाबाद हाईकोर्ट ने एक अपना जजमेंट दिया था रिसेंटली कि अगर मिसलीड किया जाता है कोर्ट को या कोई मटेरियल फैक्ट छुपाया जाता है प्लेंटिफ के द्वारा, तो उसका सूट उसी समय डिसमिस होने हो जाएगा जिस जिस टाइम पर कोर्ट को ये संज्ञान होगा, नॉलेज में आएगा कि कोई भी मटेरियल फैक्ट हाइड किया गया, कंसील किया गया है. तो क्या ये प्रोसेस सर्वर की जो रिपोर्ट है, क्या वो मटेरियल फैक्ट्स में आती है या केवल प्लेंट में जो उन्होंने
एक मिनट,
किया है वही मटेरियल फैक्ट माना जाएगा?
धीरे धीरे इसको रिपीट करेंगे, थोड़ा धीरे धीरे.
अच्छा सर मेरा क्वेश्चन ये है कि जैसे ये प्लेंटिफ बैंक को तो ये नॉलेज में था क्योंकि प्रोसेस सर्वर की रिपोर्ट जब लगी तो उन्हीं ने सूट फाइल किया, तो उनको तो पता ही है प्रोसेस सर्वर ने रिपोर्ट फाइल किया है, कोर्ट की फाइल है. तो कोर्ट की फाइल जब है, यानी जिसमें पत्रावली बोला जाता है, तो ये तो प्लेंटिफ की ही फाइल होती है. जो रिपोर्ट आती है वो बैंक अगर प्रोसेस सर्वर ने कोई रिपोर्ट फाइल की है तो प्लेंटिफ के नॉलेज में होती है और कोर्ट के नॉलेज में भी होती है.
करेक्ट.
बट उसको कोर्ट को ये होता है कि कोर्ट को लॉ पता होता है, जहां तक मेरा नॉलेज है, उसको फैक्ट बताने का काम काउंसिल का होता है. मगर प्लेंटिव बैंक के काउंसिल ने उस चीज को हाइड किया, ये नहीं बताया कि को बोरोवर की डेथ हो चुकी है, और उनको पार्टी बनाते हुए एक्स पार्टी डिग्री उनके अगेंस्ट भी हासिल करी, जबकि सूट फाइल हुआ 2018 में और को बोरोवर की डेथ हो चुकी थी 2011 में, जिसको सम्मन प्रोसेस सर्वर ने मेंशन किया अपनी रिपोर्ट में कि ऐसा हो चुका है. बट इस चीज को कोर्ट से कंसील करके एक्स पार्टी जजमेंट डिग्री हासिल कर लिया प्लेंटिव बैंक.
एक मिनट, प्रोसेस सर्वर ने द स्टाफ ऑफ द कोर्ट, तो अगर कोर्ट किसने हाइड किया, प्रोसेस सर्वर ने हाइड किया है या गलती की है?
प्रोसेस सर्वर ने हाइड नहीं किया, प्रोसेस सर्वर ने तो बताया, उसकी रिपोर्ट लगी हुई है. ये हाइड किया है काउंसिल ने, प्लेंटिव बैंक के काउंसिल, प्लेंटिव ने हाइड किया है कोर्ट से, कोर्ट को नहीं बताया. अब कोर्ट को अगर पता होता तो फिर कोर्ट तो ऐसा नहीं कर सकती कि वो
बट हाउ हाउ द कोर्ट इज इनोसेंट हियर, ये बताओ. प्रोसेस सर्वर हैज टू डायरेक्टली रिपोर्ट टू द कोर्ट, नॉट टू द काउंसिल.
यस सर, यस सर.
तो इसमें तो कोर्ट ही जिम्मेदार है इसके लिए.
बट प्लेंटिव बैंक का कहना तो ये होता है कि हमारी रिस्पॉन्सिबिलिटी नहीं, तो कोर्ट जाने, और कोर्ट कहती है कि बैंक जाने, हमें तो पता ही नहीं चला, हमें तो बताने का काम काउंसिल का है.
Process server is directly liable to the court, not to the parties, not to the plaintiff.
Okay.
So now it is between something between court and process server. Party को लेना देना नहीं है इससे.
तो अगर एज अ डिफेंडेंट एडवोकेट, हमें एज अ डिफेंडेंट काउंसिल, अगर हम इस चीज को अपोज करते हैं कि इस स्टेज पर अब आप लीगल हायर्स को नहीं ला सकते, 6-17 नहीं ला सकते आप अमेंडमेंट में, आपको जब पता था आपको तभी लाना चाहिए था, अब 4 साल बाद बीतने के अब आप लेके आ रहे हैं, तो क्या ये राइट सही है या नहीं सही है? क्या हम अपोज कर सकते हैं प्लेंटिफ का, बैंक का, या नहीं कर सकते हैं, और वो ला सकते हैं, अमेंडमेंट कर सकते हैं अपने सूट में, ओरिजिनल सूट में?
देखो आप मेरे ख्याल से व्हाट यू आर ट्राइंग, ऑर्डर 1 to 10 में आप चाह रहे हो कि इसको हम ऐड करना चाहें, आप यही तो कर रहे हो.
वो 6-17 लेके आए हैं और ऑर्डर 22-4 में वो लीगल हायर्स को अब ऑन रिकॉर्ड लाना चाहते हैं.
अच्छा, 22-4 में लाना चाहते हैं. ओके, 22-4 में दे आर ट्राइंग टू ब्रिंग ऑन रिकॉर्ड द लीगल हायर्स.
उनके नॉलेज में, प्लेंटिव बैंक के नॉलेज में तो 2018 में ही आ गया था, जब सर्वर प्रोसेसर ने अपनी रिपोर्ट सबमिट.
हाँ, तो अभी नहीं ला सकते बिकॉज द लिमिटेशन इज 3 months, 90 days.
अब नहीं ला सकते ना सर, वही मेरे
नहीं, 90 days के बाद यू कैन नॉट, द सूट अवेट्स.
ओके. और सर जो प्रोसेस सर्वर की रिपोर्ट होती है, क्या इसको मटेरियल फैक्ट माना जाता है या नहीं माना जाता?
Please. Suit abates as far this plaintiff is concerned. Plaintiff कोई legal heir लाना चाहता है वो 90 days में ला सकता है. But here you are saying legal heirs of the opposite counsel. But the opposite defendant के legal heirs, defendant के legal heirs, the defendant died, and this came to know in 2018 itself. जब plaintiff को मालूम चल गया.
यस सर, प्रोफेसर सर्वर की रिपोर्ट 2018 की फाइल है. अब वो 2025 में 22 में वो लाना चाह रहे हैं. जब डिक्री उक्री सब हो गई और हमने अपोज किया, हमने उस चीज को ऑन रिकॉर्ड लाया कि उनको पहले लाना चाहिए था.
एक बात बताओ, आप कहना चाहते हो कोर्ट को नहीं मालूम चला और प्लेंटिफ को मालूम चल गया, ये कैसे हो सकता है? कैसे प्रूव
दोनों
करोगे?
को पता था, दोनों ही को पता था, लेकिन
कैसे
उन्होंने
कह
तो
रहे हो?
डिग्री
कैसे
पारित कर
पता
दी.
था उनको? क्या आपने इंडिविजुअली इन्फॉर्म किया था?
नहीं, रिपोर्ट में तो बताया है, रिपोर्ट तो लगी हुई है.
हाँ, वही में बात हो रही है ना, इसका वो फायदा लेंगे. देखो, आपने उसको इंडिविजुअली तो बताया नहीं ना, कोर्ट
यस
ने
सर.
उनको इंडिविजुअली बताया. रिकॉर्ड पे आया, रिकॉर्ड कहीं दब गया, ना कोर्ट को मालूम चला, ना प्लेंटिफ को मालूम चला. अब जब प्लेंटिफ को जब मालूम चल रहा है, देन विद इन 3 months और विद इन लिमिटेशन इज ब्रिंगिंग दिस एप्लीकेशन, तब तो जायज है ये बात ना.
नहीं सर, पत्रावली में तो फाइल है उसकी रिपोर्ट, पत्रावली में कोर्ट की फाइल है, उसपे कागज संख्या भी पड़ी हुई है, तो कैसे कह सकते हैं कि नहीं पता? ना कोर्ट ये कह सकती है, ना तो काउंसिल ये कह सकता है प्लेंटिफ का कि नहीं पता. आपके पत्रावली में वो रिपोर्ट फाइल है, उसपे कागज संख्या भी पड़ी है.
अच्छा, पत्रावली मीन्स योर लिस्ट ऑफ डॉक्यूमेंट्स.
यस सर, जो ओरिजिनल सूट होती है, जो प्लेंटिफ की ओरिजिनल सूट की जो फाइल होती है, पत्रावली जिसको हम हिंदी में बोलते हैं, मूल
जी.
फाइल, मूल पत्रावली, उसमें आपकी रिपोर्ट फाइल है. तो आप कैसे कह सकते हैं कि नहीं हमको पता, या कोर्ट कहेगी कि हमको नहीं पता?
नहीं, ये जो लिस्ट ऑफ डॉक्यूमेंट्स है, ये प्लेंटिफ ने फाइल किया था. प्लेंटिफ ने फाइल किया था लिस्ट ऑफ डॉक्यूमेंट्स.
यस सर, यस सर, यस सर.
और उसमें ये प्रोसेस सर्वर की रिपोर्ट तो नहीं होगी उसमें.
उसमें रिपोर्ट नहीं होती है.
अब उसमें हो भी नहीं सकती. वही मैं कह रहा हूँ, जब वो लिस्ट ऑफ डॉक्यूमेंट प्लेंटिफ का है,
यस सर.
मान लीजिए प्रोसेस सर्वर ने एक रिपोर्ट लगाई, वो आके कोर्ट की फाइल में लग गई, चलो मान ली.
यस सर, यस सर.
कोर्ट इज ऑल्सो इनोसेंट हियर, प्लेंटिफ ऑल्सो
Yes.
इज ऑल्सो इनोसेंट. When the other party, opposite party informs them such thing has happened, then they came to know about it. Thereafter, the plaintiff, the limitation starts. अगर वो limitation के अंदर ला रहे हैं उस एप्लीकेशन को, उसमें क्या दिक्कत है?
फाइन सर, फाइन सर, फाइन सर.
है ना? प्रॉब्लम यहाँ पे है कि दे मे बी नोइंग. आप, मैं समझ गया आपकी बात क्या कह रहे हो. दे मे
Yes,
बी
sir.
नोइंग, लेकिन हाउ यू विल प्रूव इट?
ओके सर, ओके सर.
है ना? इस बात का पूरा फायदा उठाते हैं ये लोग. See, we also do. We also into practice. आप भी practice में हो शायद. Are you an advocate ना? आप एडवोकेट हैं? हेलो
सर.
हाँ सर, एडवोकेट है.
जी जी
यस
जी.
सर.
तो होता ही है. अब क्या करेंगे, आप जानते हो, इट्स कोर्ट क्राफ्ट. यू कैन कॉल इट अ कोर्ट क्राफ्ट.
यस सर, यस सर. सर हमारे नेक्स्ट क्वेश्चन है, क्या प्रोसेस सर्वर की रिपोर्ट को मटेरियल फैक्ट माना जाता है या नहीं माना जाता है? ये मेरा लास्ट क्वेश्चन है कि क्या
प्रोसेस
जो
सर्वर की
प्रोसेस
रिपोर्ट क्या माना जाता है?
मटेरियल फैक्ट.
हाँ, of course it's a material fact. If where where the service of summons is an issue, then process server's report is a material fact.
बिकॉज सर उसमें अभी जो इलाहाबाद हाई कोर्ट का लेजिस्लेटिव जजमेंट आया, उसमें ये कहा गया है, उसमें उन्होंने प्लेंटिफ के काउंसिल पे 50,000 की कॉस्ट भी लगाई, केवल इसी वजह से कि उन्होंने अपने प्लेंट में मटेरियल फैक्ट्स को कंसील किया और
Correct.
एक्स पार्टी डिग्री हासिल कर ली.
Correct.
तो मेरा क्वेश्चन से यही है कि क्या मैं जो ये इन्होंने प्रोसेस सर्वे की रिपोर्ट को कंसील किया है माननीय न्यायालय से, तो क्या मैं इसको रेज करके इस
Again,
क्वेश्चन को?
how can you say it has been concealed? आप कैसे कह रहे हो कंसील किया है? प्लेंटिफ ने कंसील किया. हाउ यू से दैट?
सर सर मेरा बस कंसर्न ये था कि उनकी रिपोर्ट में, उनकी फाइल में है, तो उनको पता होना चाहिए.
नहीं, किसकी फाइल में? कोर्ट फाइल में होगी ना वो तो.
हाँ, कोर्ट फाइल में सर.
सुनिए, कोर्ट फाइल में है. कोर्ट
Yes, sir.
फाइल में हर चीज जो होती है, इसका मतलब ये नहीं कि दोनों पार्टीज आर सपोज टू नो इट. दे आर सपोज टू नो इट, बट it may be possible they don't know it, because the process server's report is something which the process server issues for the court, not for the parties.
बस सर मेरे को यहाँ पे क्वेश्चन ये है कि सम्मन तो सर, जैसे हमने सूट, जो प्लेंटिव होता है वही तो सर सम्मन भेजता है डिफेंडेंट को, तो जो रिपोर्ट वापस आती है लेकर के
Plaintiff केवल
दौलत तो.
process fees फाइल करता है. Plaintiff only files the process fees. The summon is issued by the court.
ठीक है सर, ठीक है.
है ना? जब कोर्ट की जिम्मेदारी है कि कोर्ट्स रिस्पॉन्सिबिलिटी टू सी दैट समन्स आर सर्व्ड, नॉट प्लेंटिव्स, अनलेस अंटिल दस्ती सर्विस है. दस्ती समझ रहे हैं आप? दस्ती समझते हैं? कैन यू
हेलो।
हियर मी? हाँ, दस्ती समझते हैं? दस्ती
नहीं सर, नहीं सर, प्लीज एक्सप्लेन।
दस्ती मीन्स बाय हैंड। वहां क्या बोलते हैं मुझे पता नहीं, दिल्ली में दस्ती बोलते हैं।
ओके सर, ओके सर, ओके सर।
Where plaintiff can go and file an RC and get it, एक पोस्ट ऑफिस या बाय हैंड जाके डिलीवर कर सकता है, एक्नॉलेजमेंट ले सकता है, उसको दस्ती बोलते हैं, बाय हैंड।
ओके, तो मेरा सर ये क्वेश्चन जरा सा था ये कि जैसे आपने, जब उन्होंने रिपोर्ट सबमिट की, सम्मन तो भिजवाया, कोर्ट ने भेजा। सम्मन के बाद जब उन्होंने वापस रिपोर्ट आई, और एक्स पार्टी तो उन्होंने इसी को दिखा के किया कि सम्मन प्रॉपरली सर, ड्यूली सर, इसी को बेस बता के तो प्लेंटिफ एक्स पार्टी डिग्री हासिल करता है। तो जब
जी
सम्मन ड्यूली सर्व नहीं हो रहा ये उन्होंने बताया, तो क्या उन्होंने रिपोर्ट नहीं देखी? रिपोर्ट देखी तभी तो पता लगा कि सम्मन रिसीव हुआ या नहीं हुआ। तो रिपोर्ट तो देखी होगी ना। बिना रिपोर्ट देखे कैसे पता लगेगा कि सम्मन सर्व हुआ नहीं हुआ? और इसी
हाँ,
को बेस बना के तो
बिल्कुल
एक्सपर्ट डिग्री
बिल्कुल
दी है।
देखी होगी, बिल्कुल देखी होगी कि समन, आप पता नहीं रिपोर्ट में क्या लिखा था।
रिपोर्ट में ये लिखा हुआ साफ साफ कि फादर जो को बराबर की डेथ हो चुकी है। ये
को
जब बात
बॉर्डर
जब
की
लिखी
डेथ
हुई।
हो चुकी है। ओके।
यस सर। और एड्रेस जो है वो नहीं मिला, ढूंढने पे गए, एड्रेस नहीं मिला।
को बॉर्डर का कि
वो को बराबर एंड जजमेंट लेटर का तो फादर एंड सन थे, तो एड्रेस तो सेम ही था।
अच्छा, समझा समझा। बोरोवर एंड को, मतलब दोनों जो बोरोवर्स हैं उनका एड्रेस नहीं मिला, और को
जी।
बोरोवर की डेथ हो गई है।
यस सर।
ये दोनों अलग अलग गए होंगे, रिपोर्ट्स आई होंगी अलग अलग समन्स।
अलग अलग महीने में आई है रिपोर्ट, एक सितंबर में, एक अक्टूबर में, 2 बार रिपोर्ट लगी, दोनों में
तो ये
सेम बात
कोर्ट
लिखी
की
हुई थी।
गलती है, कोर्ट की गलती है, इट्स मिस्टेक ऑफ कोर्ट।
तो मिस्टेक ऑफ कोर्ट है, तो इसको एक्स पार्टी अगर हमारे अगेंस्ट हो गया तो हम इस चीज को उठा सकते हैं एज ए मटेरियल फैक्ट कि सर कोर्ट की
हाँ
गलती
हाँ,
है,
व्हाई
इसे
नॉट, यू
डिसमिस
कैन
किया जाना
रेज इट
चाहिए।
बिफोर द अपीलेट कोर्ट।
अपीलेट कोर्ट में जाएंगे, या सर जिस कोर्ट ने डिग्री पास की उसी को हम कह सकते हैं?
यू आर फॉर द डिफेंडेंट्स ना, आप
या आई एम
डिफेंडेंट
अ
के।
डिफेंडेंट। यस सर।
यस यस, यू कैन गो बिफोर द कोर्ट। लेकिन एक बात बताओ, अभी उसके लीगल एयर्स कौन है?
उसके लीगल हेल्थ में जो जो जजमेंट डेटर तो है, वो तो मेन है पार्टी है जजमेंट डेटर, और एंड उसके लीगल हेल्थ में उसके भाई बहन है और उसकी मदर को लेके आना चाहते हैं बैंक ऑन द
करेक्ट।
रिकॉर्ड।
हालांकि फादर सन और प्रॉपर्टी क्या व्हीकल है, क्या है प्रॉपर्टी?
प्रॉपर्टी हाउस थे।
हाउस है प्रॉपर्टी, फादर सन के नाम थी प्रॉपर्टी, और ये हो गया है तो डेथ होती है तो फर्स्ट क्लास लीगल हेयर्स जो है ब्रदर के, दे विल बिकम द लीगल हेयर्स, दे विल बी इंक्लूडेड एज पार्टी। ये होगा।
यस।
ये होना है, ठीक है ना?
ओके ओके सर। तो मतलब मैं प्रोसेस सर्वर की रिपोर्ट को मटेरियल फैक्ट्स में हम कंसीडर करते हैं।
हाँ,
आपने
that you will be raising in the appellate court, this has happened, this things। लेकिन उसमें ज्यादा अंतर नहीं पड़ेगा, because you are entering the appearance on behalf of both the parties। ठीक है, लीगल
यस
एड्स तो
सर।
आपको लाने पड़ेंगे रिकॉर्ड पे, फिर आप कंटेस्ट करते रहो मेरिट पे, जो भी कंटेस्ट कर।
फाइन सर, फाइन सर, थैंक यू सर।
जी,
Sir,
एनी
I
अदर
have a
क्वेश्चन?
doubt. Yes, I have a
Sir,
doubt.
I'm Rosik from Jammu and Kashmir. मेरा एक क्वेश्चन था, वो क्रिमिनल डिफेमेशन के रिगार्डिंग था। अगर किसी के खिलाफ कोई क्रिमिनल डिफेमेशन किया जाता है, उसको प्री कॉग्निजेंस नोटिस जाती है। नोटिस के साथ साथ जज ऑर्डर भी पास कर सकता है, या सिर्फ नोटिस भेज सकता है प्री कॉग्निजेंस?
सी, you are filing you're talking about 499 IPC, है ना?
Yes sir.
तो PA 499 IPC is a cognizable offense or non-cognizable offense?
No, I'm saying defamation. It's a non-cognizable offense.
Non-cognizable offense means you can try it only by a complaint under section 200.
Yes sir.
So 200 में once you file the complaint, you have to file along with this the pre-summoning evidences also.
Okay.
Court will examine the witnesses and the complainant. Thereafter, the court will try to formulate and take the cognizance. If the court thinks that if there has a prima facie matter, then the court will take cognizance and issue notice.
अगर कंप्लेंट के साथ सबूत होगा ही नहीं, अगर नोटिस इशू हुआ है लेकिन जो एक्यूज्ड है वो किसी कारण नहीं आ सका, कैन कोर्ट assume that he has nothing to say, and can court issue on the first instance issue the non-violable warrant, sorry?
अगर नोटिस इशू होने के बाद he has not appeared,
yes,
हाँ, तो कोर्ट will issue available warrant, thereafter non-available warrant.
ओके ओके। बट विदाउट, अगर उसमें मतलब फैक्ट्स होगा ही नहीं, मतलब एक विटनेस बोलता है कि इस तरह हुआ है लेकिन डेफेमेशन का सबूत है ही नहीं, ओनली टेकिंग ओथ ऑफ विटनेस कि इस तरह हुआ है,
हाँ हाँ।
मगर सबूत देखता ही नहीं है जज, कैन इट अज्यूम आल्सो अब्यूज ऑफ पावर्स?
You are saying that the court is not, yeah, who is not giving, दोबारा से बोलिएगा, कौन एविडेंस नहीं दे रहा है दोबारा से?
किसी के खिलाफ अगर कोई कंप्लेंट करता है सीजेएम कोर्ट में,
जी
डिफेमेशन कंप्लेंट करता है, ठीक है, वो बोलता है फलानी जो बंदा है ये मेरे खिलाफ इस तरह कर रहा है, उस तरह कर गलत बयानी करता है वगैरह, फिर उसके साथ वो एक गवाह भी रखता है, ये इस तरह करता है, लेकिन जज देखता ही नहीं है कि क्या किया है, नहीं है एविडेंस वायर ही हैज कमिटेड, फेसबुक पोस्ट देखता ही नहीं है, या ट्विटर पोस्ट देखता ही नहीं है, इसके बगैर ही वो कॉग्निजेंस लेता है और अरेस्ट ये।
अच्छा, you are saying that court has not gone through the evidence properly and taken cognizance.
यस सर, यस सर।
Then you can challenge it before the
Is
High
it,
Court.
can it be assumed as the abuse of powers?
Yes, yes, yes. Why not?
Okay,
Abuse
okay.
of power, negligence, whatever it is.
Yes, yes, sir. Okay.
But आप जो कह रहे हो उसका opposite ही होता है. 200 में hardly very difficult to get notice issued.
नहीं सर, एक्चुअली आई एम आल्सो एन एडवोकेट, मैं ज्यादातर नेशनल ग्रीन ट्रिब्यूनल में प्रैक्टिस करता हूँ। मैंने केस
कहाँ प्रैक्टिस करते हैं?
एनजीटी में।
अच्छा, एनजीटी में, ओके।
यस यस, मैंने केस किया
दिल्ली
था।
और आउटसाइड दिल्ली?
नो, इन दिल्ली आई एम अपीयरिंग वर्चुअली।
Okay, okay.
In the principal bench, but I'm appearing virtually from J&K cases. One of the cases there here also in the media headlines, that is destruction of 25,000 trees in the Jammu and Kashmir. And that case is going on since a year. In fact, 2 तारीख को मेरी एक हियरिंग थी एनजीटी, ये कोर्ट में मेरे केस की हियरिंग थी, तो उसमें जो रेस्पोंडेंट अथॉरिटी है, एग्जीक्यूटिव इंजीनियर ऑफ वन ऑफ द वर्क्स डिपार्टमेंट, ही अपीयर्ड ऑन द सेकंड डेट, एंड थर्ड डेट को वो नजदीकी कोर्ट में सीजेएम जो यहाँ पे उधर मेरे खिलाफ कंप्लेंट करता है कि फलानी बंदा मुझे तंग करता है, ये करता है, वो करता है, लेकिन ये बोलता ही नहीं है कि ये केस चलता है इधर एनजीटी कोर्ट में। जज मुझे नोटिस इशू करता है, प्री कॉग्निजेंस नोटिस, और मैं जज के पास जाता हूँ, मतलब जिस दिन को हियरिंग उससे पहले कि इस तरह है, मैं एडवोकेट से बोला कोई नहीं, आई विल नॉट टेक द कॉग्निजेंस ऑफ द मैटर, आप आए, चलो रिपोर्ट, आपको रिटर्न भरने की कोई जरूरत भी नहीं है। और मैं उसकी मैं फिर जाता नहीं हूँ। फिर जिस दिन इसकी हेयरिंग होती है, जिस दिन नोटिस में मुझे अपेयर होना होता है, मुझे एश्योरेंस होती है कि जज साहब को पता चला कि मामला क्या है, ये एनजीटी में वगैरह, वो एक ऑर्डर निकालता है कि ये बंदा जो है ये यहाँ पे नहीं आया, इट कैन बी अज्यूम्ड देयर इज नथिंग टू से इन हिज डिफेंस, और मेरे खिलाफ ये बायलेबल वारंट इशू करता है। आई थिंक इट इज द अब्यूज ऑफ पावर। एंड लेटर ऑन जब मैं फिर जो कंप्लेंटेंट है वो 5 दिन के बाद खुद ब खुद केस विड्रॉ करता है मेरे रिप्लाई भरने से पहले, लेकिन आई थॉट इट इज द अब्यूज ऑफ पावर। Can it be deemed as abuse of the power from the
power, because the first court assures you that nothing will happen, thereafter they issue bailable warrants again?
Yes sir, yes sir.
It is a bailable, naturally it's abuse of power.
Okay,
something
sir.
is malafide is going on somewhere.
हाँ, एंड सर अगर जब नोटिस इशू होता है, जब बीएनएस आया, प्री कॉग्निजेंस होता है, पहले सीधा कॉग्निजेंस लिया जाता, प्री कॉग्निजेंस नोटिस इशू होता है, नोटिस के साथ साथ एक ऑर्डर भी वो बोलता है मैंने इशू किया, लेकिन मेरे पास आता ही नहीं है। क्या नोटिस के साथ साथ जज ऑर्डर भी इशू कर सकता है इन सेम टाइप? नोटिस एंड ऑर्डर कैन बी इशूड साइमल्टेनियसली बिफोर टेकिंग द कॉग्निजेंस?
No, before taking cognizance, no notice can be issued to the accused.
Okay, sir.
Cognizance means the court has applied its mind and come to a conclusion that yes, the accused should be tried.
Okay. No, I am saying that if complaint, अगर प्री कॉग्निजेंस में सिर्फ नोटिस इशू होती है, उसके साथ कोई ऑर्डर इशू नहीं होता है।
प्री कॉग्निजेंस नोटिस की बात कर रहे हैं?
हाँ, क्या प्री कॉग्निजेंस नोटिस के साथ ही ऑर्डर इशू होता है, सेम दिन सेम डेट?
See, I think you are talking about the new DNS. DNS में आप कह रहे हो उसमें प्री कॉग्निजेंस नोटिस भी है?
जी।
Okay. Earlier, this CRPC never talks about pre-cognizance notice. DNS
yes.
talks about pre-cognizance notice.
बिल्कुल
Then the word they suggest it can be issued before the issuance of this cognizance of the matter.
Okay, sir.
Maybe to get the answers from the accused, the court might try to bring the accused and hold an inquiry before issuing the formal notice.
Yes, sir. No, sir. I am saying that when precognizance notice has been issued to the accused, can the judge issue a simultaneously order also with the notice?
Order of cognizance?
Yeah, order of
No, no.
intimation.
Order of intimation.
Yes.
That is the main. I think that is the main intention behind this precognizance notice, to make you apprise that something is going against you, and you come and you participate in the precognizance stage.
ओके ओके बट एक और अगर कोई मतलब अपेयर नहीं होता एक हियरिंग पे, क्या उसको एक ही हियरिंग में एब्सेंस होने के कारण ये वायलेबल वारंट इशू की जा सकते हैं, या ही हैज बी गिवन टाइम वन मोर चांस, वन मोर नोटिस पीरियड?
It depends on the court actually, but generally criminal court they are strict, at least bailable warrant to issue हो ही जाते हैं.
जी जी.
रूटीन मैनर में भी हो जाते हैं.
अच्छा, अगर एक भी हियरिंग मिस हो जाए.
हाँ, yes.
Okay sir, thank you so much.
Please.
Sir, another question.
Yes.
If a party has taken the loan and his friend is getting the guarantors, right? Once the party is not interested to repay the loan amount, then the bank send the intimation to the guarantor that you are responsible for the payable amount. But the party who has taken the loan amount have lots of property and cash is also in the account. Then guarantor says that I can't able to pay that. I'm only came for guarantor. And then the loan taken by the party can repay me. He has the ability to repay the amount. If he is not willing to repay the amount, then guarantor will be liable for that.
Then
Does the guarantor
bank,
have a solution for
bank or
this?
the person who has given the loan, the entity which has given the loan, they have a right either to proceed against both, or to proceed against the borrower or the guarantor.
Okay, but if the borrower has the ability to repay the amount, he has properties and everything.
No,
If he go
the creditor has a right to proceed either against the borrower or against the guarantor or against the both. But generally it happens that the logic says, and they follow the rule that the first the party should be caught, and the party doesn't able to pay or doesn't pay fully, then it has to be recovered from the guarantor.
but they are not seeking the just repayment from the party, sir. If they are asking from the guarantor, if the guarantor can file a petition, writ petition like
yes,
that.
yes, you are right. Yes, and under the Contract Act, Indian Contract Act, whenever guarantor pays for the borrower, that the guarantor gets a right to recover it from the borrower.
Okay, sir. Thank you.
Sir, hello.
Yes, please.
Sir, as you said, joinder of different suits, for joining of different suits, or transfer of suits to different. Suppose in a district court, different subdivisional courts are made in a district, and some suits between same parties are transferred to subdivisional courts, and some civil suits are remained in district magistrate court. So the party, either of the party can apply to district judge to join the suits at one place. Right?
Correct.
Thank you, sir.
It can be joined, provided that the court with which you are proposing should be competent to try all those suits.
Yes. And
Yes,
suits are on same property in different.
Yes. Suit property is same. Correct.
And apply to district judge court.
Yes. You can apply the district judge, and all the court subordinate can be dealt. Yes.
Thank you very much, sir. Thank you very much.
Sir, good evening, sir.
Good evening.
Sir, here Madani bin Sarmat Qureshi, sir.
Yeah, please.
I have a question, sir. Sir, if there is a criminal counter complaint on both parties on a same case, there is a counter complaint. If they make a settlement in Lok Adalat, it will be considered as convicted only, or acquittal, or whatever.
There is a criminal case. Both the parties, accused and the complainant, they make a settlement before the Lok Adalat.
Yes, sir. Both parties counter complaint.
But no. How can the criminal case be dealt in a Lok Adalat, first of all?
No, sir. National Lok Adalat, they make a settlement, no, sir. Criminal cases by
What kind
alteration
of
of.
criminal case? No, what kind of criminal case is this which can be settled in Lok Adalat? I don't understand. Means I have never come across any such criminal case.
Sir, in Lok Adalat, minor cases will be settled. That is
Okay.
compulsion or civil cases, mostly 90% civil cases. But in Telangana, sir, I have seen
Okay.
National Lok Adalat and
Okay.
Hyderabad Lok Adalat. We have seen that, sir, many cases for 448, 506, threatening, trespass, or any kind of criminal activity, they make a alteration of section and they make a settlement in Lok Adalat.
Okay.
The PP, public prosecutor, and the advocate makes the
It means what does it mean is what I can understand is in criminal case the accused says I am guilty.
Sir.
I'm guilty, but you pardon me. I think under some what you're saying, Telangana, with some state act maybe they've given the power to the Lok Adalat to settle these matters. Maybe some up to certain amount or maybe certain petty offenses. But if you are settling, no doubt, it shows that you are convicted in the sense you are guilty, but you have been admonished by the court and left pardoned, or maybe you have paid some amount and you have been pardoned. This may be the case.
Then they both will be not considered as convicted.
No, see, convicted, but again they have been let off. What I'm saying, you must have heard about Probation of Offenders Act.
What, sir?
There's the Probation of Offenders Act.
Okay, Provision of Offenders.
Offenders Act, and then there is this provision of admonition also. Certain cases you plead guilty, but the court admonishes you and warns you, and then you are let off.
Like sir, Donald Trump, he was convicted, and his conviction is not sentenced. Perhaps he is admonished also in some case. Donald Trump recently.
He has been convicted, but he has not been sentenced.
Yes, sir. Sentence is in air, something like not.
Maybe he has filed an appeal then. The appeal must be pending.
Or court, due to his position, might have sued from doing the thing.
No, it cannot excuse. The moment you convict, the sentence has to follow.
Sued, that is put back. Yeah.
Maybe there must be an appeal. There must have been a stay.
Oh, I see. Yes.
Well, the conviction sentence has to follow a conviction. You cannot avoid that. Any other question?
Sorry to disturb, sir, but actually we are out of time. If you are fine, we can proceed to the conclusion of the session then.
I'll just once again try to send you that, please.
Yeah, sure, sir.
Please hold on. Huh? Give me just 2 minutes. Just give me 2 minutes.
Sir, am I audible to you? Sir, am I audible to you?
Chaitanya.
Yes, sir.
I can do one thing. I'll just disconnect this for a minute, and then I'll send it to you. Then I'll again connect. Is it okay?
Sir, I actually we are out of time. Will it
Okay,
be
I'll do
okay
one
if
thing.
you
I'll do
share
one
it?
thing. I'll send you that thing. 3
Yeah,
pages.
yeah.
You can circulate it. Okay.
Yes, sir. Then I'll circulate it. Yes, sir.
Please. Okay.
Yes, sure, sir. Sir, thank you so much for conducting such a wonderful session. And thank you so much for answering to all the questions and patiently listening to all the participants. It's been a great session with you.
Yes. The audience has given a patient hearing. Thanks to all the audience, to all the advocates, friends, and law students who have listened to me patiently. Thank you.
Thank you so much, sir. Once again.